Welcome to the Undiluted Corner, where truth is our refrain. Relationships, health, and wealth, we're breaking every chain. Grab a seat, join the talk. In this corner, we unite. The Undiluted Corner, where we shed the light. This is the Undiluted Corner. Raw truth, real conversations.
Welcome to the Undiluted Corner. This is the installment of your 10th episode, Health, Wealth, and Relationship. I am your host, Ali, alongside my erudite co-host, Andy. Andy Wagwan Bass.
I'm there like the mayor. As usual.
Happy New Year.
Yeah, man, same to the G. Happy New Year. Viewers, let's up on yourself. We're there again.
Yeah, man. It has been a minute.
Yeah.
People are asking me, Wagwan, yeah, Andy na flex again. Andy take out your girl. Where Andy fall out over. But people who want to say everything good. I mean, I know you have been asking what is happening to the Undiluted Corner. I wonder if we get diluted or something.
Yeah.
But we want to know, so we're good. We had some technical challenges. You know, life happens, some unforeseen events. But we're resolute, we're militant,
Yeah, man.
and we made a vow that we're going to continue to give you raw truth and real conversations.
Yes, sir.
And this year, 2025, we are back bigger and better. And we would have learned, and if certain issues should come up again, then we already have mechanisms in place so we can keep the content pushing out and things. So, Andy,
Yeah, man.
tonight we have a big topic.
Yeah, man.
Willing your wealth. Willing your wealth through estate planning. Yeah?
Yes, sir.
And before we introduce the guests, more you tell the people them what them can find with.
All right, guys. So please follow us on YouTube at the Undiluted Corner. And to go on, like, share, subscribe to the channel. On Instagram, we are the _undiluted_corner. That's the _undiluted_corner. And please feel free to send us an email as well at the Undiluted Corner, the number 7 at gmail.com. That's the Undiluted Corner, the number 7 at gmail.com.
So, on this episode, to litigate this topic properly,
Yeah.
we have attorney at law, Lenroy Stewart, college man, extraordinaire. And from you know, say a college man, I want college,
Yeah.
JC, we are talking about.
Yes, sir.
Lenroy, walk on, blessings.
Well, I'm happy to be here on the Undiluted Corner with you two illustrious gentlemen. I'm looking forward to getting into this topic this evening.
Yeah, man. Welcome, Lenny.
Thank you.
Good to have you here, man.
So, Lenroy, tell the people them what you do as an attorney.
I'm primarily involved in litigation and dispute resolution, so I am in the courts a lot. I do both civil and criminal litigation with a heavier focus on civil litigation, trying to resolve disputes in the best interest of my clients.
Solid.
Yeah, man. So without further ado, we get straight into the topic. I'm gonna just get right into
Sure.
it. Lenny. We know we often hear about like putting things in place.
Yes.
For when you pass. And
Yes.
something will have to happen. See?
Yes.
And there's something where people like talk about because you know it go.
True.
But something will have to happen.
Mhm.
And we there, we work hard, we want to make sure say we put things in place with persons, after us or with loved ones or whatever. And we hear about this thing called estate planning. We kind of want you just bread back down the thing,
Sure.
tell us what is estate planning, how we go about starting doing something like that. Just give it the whole dynamic.
Definitely. So Benjamin Franklin was the one who said that the two things that are sure in life are death and taxes. And it's interesting because
Yeah.
estate planning zeroes in on those two things. So when we talk about estate planning, it involves an individual during their lifetime determining how their assets are going to be managed, used, and distributed while they are alive. Additionally, it also speaks to how an individual will want to have his assets distributed when he dies. And there is also an aspect of estate planning that has to do with what might happen to an individual if, for example, he becomes incapacitated, unable to take care of himself. So it's a comprehensive thing.
Okay, incapacitated, more kind of give you a little definition.
Definitely. So we know life, what would happen if a person has a disability, perhaps was in an accident, or maybe is hit with a mental health issue, dementia or something like that. So it's beforehand planning ahead, how will you deal with these challenges if they do pop up.
Okay. So again, it's really just, as I said, you mentioned a few words in there. How your assets, how you use, distribute, and I think you mentioned another word. So estate planning involves planning while you're alive and well.
Yes.
While you're alive and not so well.
Yes.
And also when you pass.
Yes.
So Ali, you see this thing where you have persons pass away and you have people that fight them one another and throw acid on them one another. As family members, we are talking about not strangers. And I kill them one another. Having things like this in place would kind of
serve as a mitigating factor.
Exactly.
Definitely.
And you know, we not say yo, it a go eradicate people dying, because people are gonna always die for something, things like that. Because probably even if you have something in place, people still have a fight. Say yo, we know say this him say, but you know what I mean, and create confusion and problems same way.
So Lenny, me want to zero in on a thing where you say just the word estate in and of itself.
Yes.
Now, to most people, when most people here we talk about estate, they are just thinking about land and house.
Yes.
Break back down the thing for the people. Is it about just land and house? Does it also involve things like money and all?
So, yes, all type of things that are capable of being owned. So we're talking about, there are different classifications for property, but as you mentioned, money is property. If you have a record collection, that is property. If you have a bicycle, that is your it's personal property or a chattel. And anything that you own, whether it's valuable yes or no, it's something that you can distribute. Anything that you own. In fact, as we know that sometimes something might be valueless today.
Yes.
But years down the line, some comics, for example, no limited editions, and those things have value as well.
Okay.
So, like all me now, where they did involve in a sports and thing, if me want, say boy, all of the trophy them or me did win, want bequeath those trophies to my grandchildren, right?
Yes.
That would be classified as estate as well.
Yes, your trophies, and Alistair is on the trajectory to be a very distinguished Jamaican, and so those trophies are going to be of great value. But yes, your trophies, those are personal property, those are chattels that you could bequeath in your will, distribute to your heirs. Yes.
Yeah, man, solid information.
So all right, I guess the question we have now is, so me decide say, all right, I want to take on this estate planning. What would be my first step? Do I grab a piece of paper and start write down, all right, I own XYZ, I feel like, say, my wife forget this, my youth forget this, my mother forget this. Is it a case where I just grab the piece of paper and do all of that, or I have to consult with a lawyer first?
So ideally, you want to grab the piece of paper first before you go to the lawyer. One of the things you want to do is to have a list, because you would be surprised that sometimes people forget that they own things. So you want to make a list of everything that you own, all right? You also want to take into account everything that you owe. And so even getting in the mindset of estate planning is beneficial, because it forces you to put pen to paper. And when you do that, sometimes things become clearer. And then you want to make a list of whoever you think should get your assets. And we'll get into it later, I'm sure, but you usually need some responsible persons who can assist in the process.
Okay. So
not just what you own, what you owe. And I find that powerful, Lenny.
Yes.
Because a lot of time people pass on, and companies or firms, whatever, come and claim against properties
Yes.
and so on, because they say, well, this Alistair did hold for this and that and
Yes.
whatever, and your family is in a state of disbelief because
Yes.
they must say, but me never know about this,
Yeah,
me
yeah,
never know
yeah.
about that. So that very important information, not just what you own, but also what you owe.
Yes.
Very interesting.
I see. I kind of did raise a point in terms of when putting down pen to paper, you know, who you're distributing to.
Yes.
When, say for argument's sake, a man that is married, seeing, is there a difference in terms of his estate planning versus a man that is not married?
All right, excellent question. So, in some respects, the law actually places certain obligations on individuals who are married. So, the law actually requires you, if you have minor children, you are under the law entitled, not entitled, but obligated to take care of your minor children. And so, while an individual has what the law calls testamentary freedom, so you can choose to disinherit somebody. So not because somebody is your family member, Alistair, means you're obligated to give them anything.
Okay,
But when we have minor children and when we have spouses, those are two categories of persons that the law says you have to maintain them. And so if you're dealing with your estate plan, if you are, you feel like you're in the prime of your life, but you have minor children, in your estate plan, there should be a mechanism to take care of your minor children and your spouse as well.
That's a great point, you know. That's a great. So it's really non-negotiable for them to.
Right. If it is that the child is an adult, it's a different question, and you generally have the testamentary capacity to decide freedom to decide if you want to leave something for an adult child or not.
So your estate planning is really you calling the shots.
Yes. Because if you don't, then the law is going to dictate how your assets are going to be distributed, and it may be in a way that you don't want.
I see.
Very interesting.
Yeah.
So here it get dicey now, Lenny.
Yeah.
So a man married for 20 years.
Yes.
Separates from his wife. There's known divorce. Goes venture into another relationship.
Yes.
Venture into another relationship. The other relationship lasts probably even longer.
Yes.
For another 25 or 30 years.
Yes.
He dies.
Yes.
And before he dies, he would want to leave most of what he owns for the second woman that he was in a long-term relationship with.
Yes.
Now, remember, him never divorced from his wife. Can his wife claim on his asset, given that he never actually pursued a divorce?
Well, so if he did not make a will, what the law says is that the person who stands in first place to extract what we call a grant of administration, and to explain what that is, when somebody dies with a will, that person is said to have died testate. When a person dies without a will, that person is said to have died intestate. When a person dies testate, in the will he will name executors who can apply for what we call a grant of probate. The probate is essentially a court order which says that this person is empowered to deal with the assets of the deceased as contained in the will. This is the person who is going to distribute and ensure that whoever is supposed to get gets. When we come to a person who didn't leave a will now, that person dies intestate, the first person who can apply is the wife. And so in the factual scenario that you gave Alistair, even though he had been estranged but not divorced.
And him leave the will.
So if he leaves the will, that's a different question. And in that way it would show the power of the will, because in the will he can set out who can get what, who is supposed to get what. But if he didn't leave a will, this wife who has been out of the picture for 20 years, she could come back, and because the law says the wife is in first place, she could apply for the grant, and automatically she would be getting a share of his estate.
Interesting. So
Yes.
where he leaves the will,
Yes.
because this is getting very interesting now.
Yeah.
Where he leaves a will, in spite of the fact that him never divorced, in spite of the fact that they are not divorced,
Yes.
under the law, she is still his wife. We
Yes.
want it very, very
First place.
pellucid.
Yes.
Is she still first place? Can for example, the second lady, when in a long-term relationship with a boy, the wife now get nothing. I mean, just the children, them and she and whoever.
All right, so that is why the estate plan is so important, because
Yeah.
a lot depends, as we said, whether the person had a will.
Yeah,
If
yeah.
the person had a will, his will indicates what are his wishes, how he wants things to go. And unless there is a ground for a valid challenge, then the will, once the court issues that grant of probate and says that this will is valid, it is valid until it's set aside, unless it's set aside. So the will is powerful.
All right. So if we continue and at this point, if he actually makes that will
Yes.
and put the second woman as his first lady,
Yes.
that stands.
That stands, yes. Unless, so here's how it gets tricky now. When we talk about property, we want to look at the way in which the property was held. All right? So, in law, property can be jointly owned. And depending on how the property is owned, it dictates. So, let's say, for example, in law, we have a concept called joint tenancy. So, A and B own a property. If A dies and the property was held as joint tenants, the law has a concept called the right of survivorship. So A dies, they were joint tenants. What the law says is automatically A's interest passes to B.
Okay.
And so it's another reason why estate plan is important. You don't want to leave it to chance, because I have, for example, dealt with cases where people wanted to do something, but they didn't get the right advice. And even though they had the intention, so for example, something like the joint tenancy hit them, and their intentions were not made good because the law operated and the operation of law had to be carried out. So critical.
Okay. Very interesting stuff, Ali.
Very, very interesting.
Yeah, and you bring me to the next point as well, Lenny, where you mentioned will. So I want you kind of, if there is, kind of give you a distinction between what is estate planning versus what is a will.
All right.
Or
So
is will just included as a part of estate planning?
yes, so a will is one of the tools that you can use to achieve the goals that you have in estate planning. Surprisingly, for those who are specialists in estate planning, one of the things that they say is give it away before you die. So if it is that there is a charity that you want to support, right?
Yeah.
Do it while you're alive. Oftentimes that can prevent a lot of problems. That can prevent a lot of problems. So in the fancy term for it in law, we call it an inter vivos transfer. So inter vivos, while you are alive, give it away while you're alive. But a will is one tool that can be used to achieve the aims of your estate plan.
Okay.
Can you tell us some more of the tools in the box?
Sure. So
that is usually used?
one of the things we mentioned medically, you might want to consider a power of attorney. All right. So for example, you know that you're going to undergo a medical procedure. The doctor say, listen, it's touch and go. If you come, you might have these serious challenges. They might be, debilitating. And so before you undergo that medical procedure, you might want to do a power of attorney. This is a legal document, a deed, by which you authorize someone to do specific acts. It can be specific, or you authorize someone to do general acts. So the power of attorney is one tool. We also have a trust. So it's a legal vehicle for example, doing things that somebody who is a settler of the trust wishes to do. So there are a number of famous institutions that were actually created by trusts. So for example, certain schools, the National Housing Trust. So a trust is one vehicle. We mentioned the will. And another thing that you can do is also considering how you own property. So holding property in a particular way can also be carrying out your aims of estate planning.
I got you. So it all depends on, I guess, it all depends on the specific scenario.
Definitely. There's no one size fits all. Yeah.
Okay. Got you. Boy, I did think initially I thought this was a regular topic still in the alley.
Big topic, man.
But a solid topic, man. A solid topic, which we need to start do some estate planning from now. You know, see it.
Yeah.
Is there like a specific age or a required age where you just say, all right, when they reach X amount of age, start do some planning?
Right. So one of the things that the estate planning consultant. All right. So the first thing I'll say is, in terms of making a will, you have to be over 18 to make a will. All right, by law. But one thing persons say is, whenever you have major life events, you want to look at your estate plan. So, for example, the birth of a child, as we mentioned, when you get married. And Alistair, why when you get married is so critical, what a lot of people do not know is, let's just say, as a single man, you make a will. And I know you guys are interested. You make a will as a single man. What persons don't know is that when you get married, by operation of law, the law automatically voids your will. So when you get married, you need to make a new will.
A new will, automatic.
Automatic, yes.
Okay.
Yes. So,
very
as I said, it's one of the reasons why advice is so important. I have seen, for example, a particular case where a lady and a gentleman, they were in a relationship. All right. The man made a will, and afterwards he got married. And sadly, he died shortly thereafter. And the will was automatically invalidated. So it's things like these that people need to know, and why estate planning is so important.
So even though initially we were saying estate planning supposed to reduce the whole heap of tugging and warring, but if not done properly, it still can cause some tugging and warring.
Yes.
So, can the will be contested?
A will can be contested. There are a number of grounds.
Yeah, and based on, right, I was about to ask, based on your experience out there in court, what are some of the reasons that you would have come across?
Yes.
Some of the instances where people would have contested wills.
All right, so in Jamaica, we have an old piece of legislation that is called the Wills Act. And it sets out the formalities. These are things that you have to have for your will to be considered valid. One of the important things, it seems simple, it sounds simple, we're in an age of AI and all kind of things. The will has to be in writing. So if you sit and on an episode of the Undiluted Corner, you video record your will.
Yes.
Under Jamaican law, it's not a valid will. Your will has to be in writing. Yeah, so that can be the first challenge. So if it is in writing, you pass that hurdle. There are some other formalities. So the person who makes the will is called the testator. The testator has to sign the will. So if you do your fancy will and it's not signed, it's not valid. The will also has to be witnessed in accordance with the specifications of the Wills Act. So for example, you need 2 witnesses. So if only one person witnesses your will, it's not valid. It's invalid. So these are some things that you want to know. There are some other little things, but you want to ensure that your will complies with the formalities. There are other grounds for challenge. So for example, persons may think that the testator was unduly influenced. All right, let's just say the testator is getting of old age, and there is somebody who is maybe, you know, a caregiver, or somebody who is exerting a domineering influence over this person, pressuring the person. Mr. Joe, more you left this for me, and the person might be isolated from family members,
Undue pressure.
and so feels like if he do give this person the thing, he will face harm because he can't take care of himself so well, and so undue influence is a ground for challenging.
They would say the person would have made the will under duress.
Under duress, yes.
How would we contest that?
All right. So, well, a claim stands and falls on the evidence. So there would have to be evidence. Somebody would have to come and says, yes, this is something that I see. I can document. I can attest to the fact that the helper was pressured. Maybe it's the gardener or somebody who sees. So a claim stands and falls on the evidence. So duress or undue influence. Another thing is the testator must have mental capacity. And so if it can be proven that the testator did not have the mental capacity to make the will, he didn't know and understand what he was doing. Yes, he knows how to sign, but somebody put a paper before him and he just signed it, you know. That is something that is also a ground for challenge. Yes.
Interesting stuff. I kind of went jump over to another side just a little bit.
Sure.
Because we want to make sure so we cover everybody still. Persons with special abilities.
Yes.
Or disabilities.
Yes.
Is there anything different in the whole estate planning for them compared to others?
The short answer is no, because once a person has assets, they can leave their assets to whomever they choose. So the short answer is no. There might be some specifications. So for example, if a person is visually impaired, his will have to be witnessed in a particular manner to ensure that it's valid. All right, so we have the marksman clause. So it's just to ensure that it's valid, but the short answer is no. If you have assets, you plan for them, you manage them, leave them to whomever you choose.
All right, so that example, say somebody is visually impaired. Is it a case that their will should be written with a braille?
So let's put it this way. The law says that it has to be in writing. So that includes it being typed, all right? It doesn't have to be in English necessarily. And so Braille would satisfy the requirements of the Wills Act. Yes.
Yeah, because why may I think about it that way is I know it's supposed to be prepared by the you give me a term.
The executor?
No, prepared by the
attorney at law.
You are prepared.
Testator.
The testator. Yeah, that's the testator. So I'm thinking if the testator is blind, if you have a will that is valid, I expect it to be in braille.
So it could be in writing, actually. It could be in writing, and in the will, there would need to be a clause to specify that the will was read over to the individual. He affirms. And when we talk about signature, there are some decided cases that an X, if the X is your mark, the X can stand as your signature. There are some cases which would say that even a thumbprint in ink can stand as the person's signature. And I know from experience that many visually impaired persons are able to sign their name and write. So that stands as well.
Got you. And I mean, again, we want to make sure we cover
all the bases. Sure.
A young man starting out in business.
Yes.
Is there any specific consideration for persons like that?
So once you're, for example, when we look at wills, once you're over 18, you can make a will. So one of the things that your will can do, and this is an importance in the nature of a will. So a will speaks from the date of your death. So let's just say you are 20 years old and you say you want to leave everything that you own to your sister. Even though at 20 you don't own anything, if 60 years later you die, everything that you own, not at the point that you made the will, but at the point that you die,
Yes.
everything will go to your
So I
sister.
can forecast.
You
So
can
boy,
forecast, yes.
You know, me I gonna make multiples of millions.
Yes, you can forecast.
And down the line, when I die,
Yes.
those millions go to my sister.
It can happen that way. It's recommended, as we said, that after major life events, you review and update. But if you would have made a will, for example, as a young man, and you don't change it, and 60 years later, 70, 80, however you're deceased, the beneficiary is still alive, that person will get the will you made years earlier. They will get the benefits in that will, yes.
All right. I want to ask a question. I think you kind of touched on it still, but just to be clear. So say you made a will, right? You have 2 kids.
Yes.
And you have a business and you say, all right, I want my kids to take over my business when I pass. But the specifics of it, you probably leave out. You probably leave out to say, all right, you have a boy and a girl, you want the boy to be the CEO, or you want the girl to be the CFO, or there's nothing specific in it. In terms of managing that business, is anything by law, or what is then used to steer the operation of the business?
All right, sure. So it goes into an area of the type of business or how the business is held, because there are different vehicles, as you know, for holding, owning, different business vehicles. So, for example, if a person is what we call a sole proprietorship, that business dies with him. So you want to make sure that if it is that you want to leave a legacy, your business vehicle has to be one in which, for example, maybe shares can be passed down. So then you would want to incorporate a company. And if you incorporate a company, ownership rights in the company via shares or otherwise, that can actually be passed down. The companies, what we call the company's articles, those documents would really dictate what can be done, and so you would want to ensure that those documents speak to it. Again, we spoke about the fact that sometimes it's better to do something while you are alive, and so what you may want to do is bring the children in the business before you pass. But there are ways and means of ensuring that your wishes can be carried out. So it is something that is done, yes. Companies, shares in companies, and so on, your will can speak to those things, yes.
Okay. And I guess if you're not of age, then also your will speak to.
So there, right. So for example, we mentioned the trust. So the trust is one of the vehicles that can be used to provide for minor children until the children reach a certain age and until they are able to manage the money themselves. There is a concept, yes. So for example, there could be a trustee who basically is in charge of the property until the child comes of age. So within the kit of the estate planner, there are options that can deal with those situations.
So, I mean, long and short of it is, you putting together your estate planning, you definitely have to get a lawyer involved to kind of dot the I's and cross the T's.
It's advisable and recommended. The truth is, you do not need a lawyer to do a will, but it's advisable. Back in the days, there were some things that were a lot more common knowledge, and so you can. So, for example, if you have your Wills Act and you read it properly, you can make a will without the assistance of a lawyer. But I would recommend it. There are some pitfalls, and you wouldn't want to go through the trouble of making a will for it to be declared invalid.
Andy, Lenny, we know we never have this as part of the question, but I'm just here sitting and listening, and I want to find out if someone did sign a prenup,
Yes.
right? If someone signed a prenup, would that be part of the whole estate planning
So
as
that
well?
definitely, Alistair, that can be a part of an estate plan as well. Jamaican law recognizes both prenuptial and postnuptial
And
agreements.
postnuptial,
So that could be a part of an estate plan as well. Yeah, yeah.
Yeah, because sometimes persons, you start out, you marry with certain conditions. You set out your prenuptials, and then as the marriage go on longer
Yes.
and longer, and the love grows and the confidence builds.
Yes.
Then you say, well, I need to share more of what I had before. Whatever, so yeah, man, that's timely, Lenny.
Yes.
They say she
Yeah,
deserve
man.
a little more.
She deserve a little more, so you go in and change and update it. Yeah, man.
Jump in for the kitty. Yeah, man. I mean, pretty good discussion still.
Yeah.
Solid.
I like it, Ali. Like
Yeah, man, this is very key. A lot of persons don't pay a lot of attention to estate planning, but I mean, it is very important. I mean, a lot of men work very hard, and you had a loving family and thing, and you're very complacent. You just believe, so boy, when you drop out, everybody are going to just share up all of the spoils, and everybody are going to move on equitably. Yeah, man, that is the word, equitably. And people are going to just move on happy, but there are many instances, countless instances where it does not work out that way. So we want to thank our very shrewd attorney, Lenroy, for come out and, educate us on what estate planning is all about.
Yeah, man.
So before we jump out, Lenny, we want to tell the people them where them can find you for legal advice.
Sure. I work at Wilkinson Law, attorneys at law, and so I'm at 14 Ruthven Road. That is where you can find me. But we encourage your viewers to do the necessary research. There are people who specialize in estate planning, and so get some referrals, call around. It's an investment that redounds to the benefit of future generations. Persons will talk about the importance of generational wealth. The truth is, for a simple will, if you know what you're about, a simple will is not going to break the bank. So it's one of the more affordable legal service that's provided. There are some other estates that are quite intricate and more hands-on, but for the average person, a simple will, doing your estate plan, it's not going to break the bank. It's affordable, and it will benefit future generations.
So I mean, any final words for the viewers?
Well, there are some pitfalls, and so it's important to get advice. One of the things is that many Jamaicans in particular, they will think that making a will means that you are going to die. But there are some benefits. I'll share a quick story.
Yes, ma'am.
I know a lady, she's in her 80s, and about 30 or so years ago, she made the dress that she's going to be buried in. She went and paid for the vault at the cemetery, and the amount that she paid compared to today's date, she got a deal. And she's still alive and kicking today. So when you do these things and you,
So she did something that was inflation proof.
I tell you, when you do things like that, she's sitting pretty. When the time comes for her to go to her rest, her relatives are not going to be worried.
Proper planning.
She dealt with that a long time ago.
Proper planning that. So no stress for
Yes.
whosoever leave.
Yes.
Alright, cool.
Yeah,
So Andy,
man.
yeah, man, good episode.
Yeah, man. Yeah,
Tell
man.
the people them where them can find you again.
So guys, we are the Undiluted Corner on YouTube. Again, go on, click, share, follow, the whole works. We also pay attention to the comments as well. So if there are any specific questions that you guys want to ask, please feel free to put them in the comments. If not, then you can reach us on our email at the Undiluted Corner, the number 7 at gmail.com. That's the Undiluted Corner, the number 7 at gmail.com. We're also on Instagram at the _undiluted_ corner. That's the _undiluted_ corner. Yeah, man.
Raw truth, real
conversations.
conversations.
Until next time, big up on yourself.
Bless.
Out.
Thanks for joining us in the Undiluted Corner, where insights abound and perspectives are born. Relationships, health, and wealth, we've explored them all. Until next time, let's continue to stand tall. Subscribe, share, and keep the conversation alive in the Undiluted Corner, where truths thrive until we meet again. Let's keep our hearts light. The Undiluted Corner, shining ever so bright.